The Law Report with Karen Key.
And a very good evening to you from tonight's Law Report programme. Well, in March, the Department of Home Affairs issued stern warnings to workers, cautioning them against taking part in illegal strikes. Then in April, the Post Office dismissed several workers for violating a court order prohibiting workers from taking part in an illegal gathering. Now, these types of events highlight the need for insurance against labour disputes. And this is according to Simon Colman, underwriting executive at SHA Specialist Underwriters, who says that these types of labour dispute scenarios are becoming increasingly prevalent in South Africa and are prime examples of the labour relations tightrope that employers are constantly treading. Simon, good evening. Welcome to the show.
Good evening to you too, Karen. Thank you for having me.
You know, we're always talking about the workers' rights and what the workers need to do and, you know, all the things relating to them and how they can take things to the CCMA, but we never really look at the companies, how they could be protecting themselves.
Yeah, it's a fact. And I think even though this thing called employment practices liability insurance has been around for quite a while, a startlingly low number of businesses actually have the insurance. So it's not really marketed very effectively in South Africa. And that makes no sense because we've got this enormous caseload at the CCMA and the bargaining councils each year.
Now, what can they do? I'm to be talking insurance here. I mean, but the companies are spending so much money anyway on all sorts of other things. Can they afford to cover themselves?
Well, look, I think, it's one of those things where you really need to know what these things cost before knowing whether or not it's affordable. And most of the insurers that offer this type of cover have pitched it at a level which is very affordable for small businesses in particular. And those are really the guys that, you know, they get taken to the CCMA. Often they don't have representation, so, you know, at least half of the time they're losing the cases. So, you know, to spend 300, 400, 500 rand a month on an insurance policy that takes away some of that uncertainty at the CCMA, you know, I think that, I mean, I don't know what businesses can afford, but that sounds like it's in the realms of affordability.
Now, the thing about the CCMA, which is a wonderful resource for employees, and it's a free resource for them, and one often finds that we're in a case where a dismissal was actually justified, the employee will still take the case to the CCMA, and in some cases, the employer still ends up having to pay.
Look, the CCMA is a real success story in South Africa, and in fact in labour generally, if you look at other countries. You know, it's a tribunal that responds very quickly. Their turnaround time is generally less than the 30 or 40 days that they set out to achieve. But of course, when you've got a free resource, it also means that, you know, everybody's going to have their day in court, perhaps even when it's not really justified. So you're quite right. What we see is, you know, literally cases where an employee has been caught stealing from the employer. They then go through the disciplinary process, they're dismissed, and they still approach the CCMA. And of course, the CCMA has to hear that matter. And what you can also find is that employers had a good reason for proceeding with the dismissal. In other words, it was substantively fair, but they didn't follow the procedures. And of course, when that happens, that's when the case is lost. So it's all about education. Employers are actually getting very good at dealing with what we call misconduct cases. So things like theft or a dereliction of duty or some other misconduct in the workplace. Because they've got set procedures that they can follow, they're able to do that quite effectively. And if you look at the CCMA stats for the last couple of years, you'll see that employers actually win 70 to 80% of those type of cases. Where they're not so successful is on incapacity issues. In other words, things that relate to work performance or even illness in the workplace. It's something that every business worries about. You know, even if you do the right thing, you're probably still going to have to go to the CCMA and defend yourself.
Now, the other thing as well that we've seen a lot of are the wage negotiations, and sometimes the asking increase is, you look at that and you think that is just really not doable at all, but yet it drags on, and then you end up sometimes with illegal strikes happening and all sorts of other things. How can the employer cover themselves? What would this insurance cover them for?
Yeah, look, I mean, the strike issue is a difficult one. So most of these type of insurance policies, you must remember that one thing you can never do in insurance is do anything that's against public policy. And you certainly wouldn't want to come up with an insurance policy that gives the employer the ability not to negotiate with employees, because we'd be messing with the delicate framework that exists in the labor environment. What you can do, though, is you can insure yourself against those unprotected strikes. So, if the employees aren't following the procedure and they've gone on a wildcat strike, and then there's dismissal action or other disciplinary action that needs to follow that, you could buy insurance against those legal costs and damages. But the way our country operates at the moment, it just seems that every wage negotiation has the potential to end in a strike. And while everybody acknowledges that everyone deserves a wage that they can live on, sometimes the economics just don't add up at all.
So it's quite a difficult situation and difficult environment to work in then.
So difficult. Where workers are striking legally, the only way out of that is through negotiation. And again, the CCMA are very effective we mustn't think that they only deal with unfair dismissals. They deal with a lot of these far-reaching bargaining agreements and disputes, and their mediation process is quite robust as well. You saw it in the mining sector. Something can drag on for a year, if not longer, before it gets resolved. And there isn't really an insurance solution to that problem, unfortunately.
Now, you mentioned a little while ago the percentages of cases won by the employer as opposed to won by the employees, and yet a lot of employers still perceive the CCMA to be biased towards the employee.
I think that sense comes out of the fact that even cases that appear to be in favor of the employer from the outset still have to go through the process. So employers are going, listen, I caught this guy stealing from me, got him red-handed, it's on CCTV, we followed all the procedure, and yet I still have to go to the CCMA. They then arrive at the CCMA, and the thing that the commissioners are trained to do first is to try and settle the matter. So, of course, the employer is sitting there going, why should I even think about settling when I was justified in doing what I needed to do, and yet I feel like I'm being pressured into something. And, of course, the unfortunate thing about settlement negotiations is because it's time-consuming and sometimes costly to go to the CCMA, the employer might be tempted to just settle the matter, even though they knew they were going to win it. And I think that's why often there's this sense, that employer comes out of that meeting, he tells his other friends that run their businesses that this is what's just happened, and then you've got this perception that just perpetuates. And actually, when you look at the statistics, most of the cases are still going in favor of the employer.
Yeah, I was quite surprised when you gave me that percentage because, you listen to people telling stories, you wouldn't have thought it was that high.
Yeah, look, it's not something the CCMA publish regularly. They produce amazing annual reports, but, you want the organization to maintain its neutrality. And a 50-50 split is more likely to be the one, or that's the one you'd be hoping for. But when you really look at, there's an organization called Tukiso, which is a private arbitration forum that produce an amazing digest of all of the results of these matters. And they show quite clearly in there that overwhelmingly employers are winning their cases.
Now, we've been talking all the time now about the insurance, and we're talking here about employment practices liability. Is that what it's called?
That's what it's called, yeah. Labor dispute insurance would probably be a more accurate name, but we don't like to have accurate names in insurance.
Rather call it something sort of vague, Employment practices liability. Okay, It sounds very posh. We'll stick with that then. Now, what exactly does that do, and how does it completely cover the employer?
It's a policy it's a short-term insurance policy, so it would be annually renewable, and then the employer would take it out. And then if they have any unfair dismissals are probably the cases that get dealt with the most by an employment practices policy. But discrimination, sexual harassment allegations, those things are also dealt with by the policy. So what I mean when I say dealt with, employer would receive some kind of notification from an employee or from their legal representative saying that there's a dispute and it's been reported to the CCMA or to some other body. And the employer would then notify their insurers, and the insurance policy then pays for the defense costs and the investigation costs for the employer. And if the case is then unsuccessfully defended at the CCMA or in the labour court, then the policy would also pay whatever the award is that's made by the CCMA.
Now, as you mentioned, it's got to be a case that's reported. It can't just be the employer sort of coming to the company and saying, well, there's this dispute and could you just help me out and we'll just pay off the employee. It doesn't work like that. No,
it's certainly not what we'd call a golden handshake policy, which would be quite useful in some state environments. It's more something that's saying, look, as something unexpected has happened. I should also stress at this point that it's not a policy that's designed to give employers the ability not to follow procedure, because it can be perceived that way. You know, if I say I'm going to cover an unfair dismissal, am I saying that the employer can do whatever they want and that case is going to be covered by this policy? In that case, they could just dismiss any worker without following procedure. And it doesn't work like that. It says you as the employer must endeavor to follow your own procedures and those laid out in the Labour Relations Act. What we are doing is we're taking the uncertainty out of the decision that's made by the CCMA Commissioner, because you don't always agree with those decisions that are made. Commissioners are not judges, which means they're not bound by their own or by any precedent set by another commissioner. So what you often find is that two similar cases could have very different outcomes. And the policy takes away that uncertainty. So it's still saying you've got to follow procedure as much as you can, but we'll cover the defense costs when you get taken to the CCMA, and if you lose the case, then the policy is going to pay the back pay if the employee is reinstated, or it will pay whatever the award is if compensation is awarded by the commissioner or by the labour court.
So the labour court, the CCMA, or even a bargaining council.
That's right, yeah, any of those.
Okay, but it's got to be an official body, and as you say, the most important thing people need to understand is that procedure has to be followed here.
They have to do whatever they can to follow procedure. We accept that sometimes a very strong case turns into a weak one. In fact, I'd say most of the cases where our employers have lost have been where, by the time the matter gets to the CCMA arbitration, two key witnesses also no longer work for the company or are unavailable or aren't prepared to give evidence. And then you find that, some key witnesses now, the case has gone from being very strong to being quite flimsy, and then settlement is normally negotiated.
Well, I'm sure a lot of employers who are listening who didn't know about this are thinking, gosh, well, this is what I've been waiting for all this time, and now they are able to get that. And would they find more information on the website, Simon?
They could go to sha.co.za, our website, or they could also get hold of me, Simon, at sha.co.za. But the way we operate in our business is all of our referrals come from insurance brokers. So the right thing for them to do is to contact their short-term insurance brokers who will probably already have an agency with us, and then we can start negotiating.
And the official name of this is called the Employment Practices Liability, EPL, basically. Just a fancy name for a labour dispute insurance, effectively.
That's correct.
Right. Simon, well, thank you very much for joining us this evening, and you'll be back with us again a little bit later in the show. But thank you so much for your time now telling us about this. Thank you.
Thank you very much.
Simon Colman is an underwriting executive at SHA Specialist Underwriters, and for more information you can take a look at the website. It's www.sha.co.za, or you can email Simon at sha.co.za. But as Simon says, the best way for you to go is through your short-term insurance broker. So have a chat with them, talk to them about employment practices liability.